Honorable judges, distinguished colleagues, my name is Michael Cunningham, representing the World Affairs Council of Austin. We convene today in a preliminary hearing to determine whether the International Court of Justice should hear the case concerning the 23 Artsakh citizens tried in Baku. This is not yet a trial on the merits. It is a grand jury-style inquiry into whether the principles of sovereignty, jurisdiction, and sovereign immunity demand that the court take this case forward. The first issue is sovereignty. The trial of the 23 Artsakh citizens in Baku was conducted under conditions that violated fundamental principles of international law. These individuals were leaders and officials of a self-governing entity. To prosecute them as criminals for exercising governance is to deny the principle of self-determination and to criminalize sovereignty itself. International law is clear. Sovereignty cannot be stripped by unilateral action. The ICJ has consistently ruled that sovereignty must be respected, even in contested territories. The second issue is jurisdiction. Azerbaijan claims jurisdiction over these individuals, but jurisdiction must be lawful. The ICJ exists precisely to adjudicate disputes where domestic courts cannot provide impartial justice. The trials in Baku lack transparency, independence, and fairness. Jurisdiction exercised under coercion or occupation is invalid. Only the ICJ can determine whether Azerbaijan's claims of jurisdiction are lawful. The third issue is sovereign immunity. Heads of state, ministers, and senior officials enjoy immunity from prosecution in foreign courts while in office. This principle was affirmed in the arrest warrant case, Democratic Republic of the Congo versus Belgium, in 2002. By prosecuting former presidents, ministers, and parliamentarians of Artsakh, Azerbaijan violated the principle of sovereign immunity. These individuals were acting in their official capacity, and their prosecution undermines the sovereign equality of states. The fourth issue is the Treaty of Kars. Azerbaijan's claims rest in part on territorial arrangements derived from this treaty, yet the Treaty of Kars was signed in 1921 by the Turkish National Army in Artsakh, an entity that had no legal standing to negotiate or sign treaties. Under the Vienna Convention on the Law of Treaties, treaties signed by parties without lawful capacity are void. The Turkish National Army was not a recognized sovereign government. Therefore, any grant of land under the Treaty of Kars is legally invalid. To base jurisdiction or sovereignty claims on such a treaty is, honestly, to build on illegality. Honorable judges, the question before you is not whether Azerbaijan is right or wrong. It is whether the issues raised, illegal trial, sovereignty, jurisdiction, sovereign immunity, and invalid treaty claims, are serious enough to warrant the full attention of the International Court of Justice. I submit to you that they are. The stakes are high, the principles are fundamental, and the precedents are clear. For these reasons, we respectfully urge that this case proceed to trial before the ICJ. Thank you.